begin with a quick introduction. E-commerce means buying and selling goods through the internet using platforms like Shopee, Amazon, and Lazada. Over the years, e-commerce has grown rapidly due to high internet usage, technology-savvy users, and government support for digital business. People now prefer online shopping because it's more convenient and often cheaper than traditional shopping. However, laws like the Consumer Protection Act 1999, which were made for traditional purchases, are not enough to protect online consumers. To fix this, the government introduced new laws such as the Electronic Commerce Act 2006 and the Consumer Protection Electronic Trade Transaction Regulation 2012. These laws aim to protect buyers in online transactions. Still, e-commerce brings new challenges like no face-to-face interaction, fake ads, and privacy concerns. That's why courts now play an important role in making sure these laws are enforced to protect customers. In this presentation, we will explore the legal framework, challenges, court cases, and the effectiveness of current laws, and we also will give the recommendations to improve consumer protection in e-commerce.
Hello, my name is Elina, and I will be explaining on the legal framework which governs consumer protection in e-commerce. In Malaysia, there are several laws that help to protect consumers when shopping online. And the main one is the Consumer Protection Act 1999, which ensures that goods and services are safe, of good quality, and match what was promised. It also bans false advertising and unfair terms, and an important update in 2007 helped to include online transactions, which means that online shoppers would get the same rights as those buying in stores. And therefore, this Act helped to offer a simple way to settle disputes through the Tribunal for Consumer Claims. And to further support the CPA 1999, the Consumer Protection Electronic Trade Transactions Regulations 2012 were introduced. These rules help to make online sellers show important details such as their name, business number, and contact info. They must also let buyers correct mistakes before placing orders and confirm the sale afterwards. Sellers need to keep records, and if they don't follow the rules, they can face legal action. Next, the Electronic Commerce Act 2006 supports online business by giving legal value to electronic messages and agreements. For example, by clicking on I agree online can count as signing a contract. This law also ensures that electronic documents and signatures are accepted in court, which makes online transactions more reliable. Next, we have the Contracts Act 1950, which explains how contracts work, including online ones. And it says that a valid contract must have an offer, acceptance, consideration, intention, and legal capacity. And even though this law is not made during the digital era as ours today, it still helps to ensure fairness in online buying. Next, it is the Sale of Goods Act 1957, which helps to ensure that goods sold online must match their description and be of acceptable quality. This act also requires sellers to deliver what was promised and buyers to pay for what they had received. This helped to protect shoppers from getting faulty or misrepresented products. And finally, we have the Personal Data Protection Act 2010, which protects people's personal information during online transactions. Businesses must get consent to use customer data and take steps to keep them safe. However, not all businesses follow these rules, and therefore more action is needed to make online shopping safer and build trust in consumer protection. Next, I'm going to explain on the legal issues in consumer protection e-commerce. Online shopping presents several legal challenges, such as firstly, consumers could not physically inspect products before buying, which would lead to disappointment when items do not match their expectations. And although the Consumer Protection Act 1999 requires accurate product descriptions, it still does not fully solve this issue. Secondly, misleading ads are common, such as sellers may exaggerate claims or use edited images, and influencer promotions are not always fully transparent. And while the law prohibits false advertising, enforcement is harder online, especially with foreign sellers. And lastly, privacy is still a major concern in e-commerce. This is because shoppers often share personal data, and if businesses mishandle them, it can lead to identity theft or data breaches. And although the PDPDA 2010 offers protection, enforcement gaps and unclear data use policies leave consumers vulnerable still. And therefore, stronger enforcement and transparency are needed to make e-commerce safer for everyone involved. That is all from me. Thank you.
Move to the next part, which is judicial interpretation and case law. When it comes to consumer protection, the Consumer Protection Act 1999 (CPA) is the main law applied by the courts. However, after e-commerce became more common, the court started to apply other laws like the Electronic Commerce Act 2006 and the Consumer Protection Electronic Trade Transactions Regulation 2012 together with the CPA. And for example, in the case of Telekom Malaysia Berhad against Tribunal Tuntutan Pengguna and UMNO 2007, the court said that at that time, online transactions were not covered under the CPA unless stated otherwise. This means that consumers who bought things online were not protected under the old law. But now, after the amendments, these laws officially apply to online transactions, giving better protection to online shoppers in cases like fraud, defective products, and misleading advertisements. Another important case is Datuk Vijay Kumar against Malaysia Airlines 2021. The plaintiffs bought flight tickets online, but due to the pandemic, the flight was cancelled. They refused to reschedule and wanted a refund, which the airline rejected. The court ruled in favor of the airline, saying the cancellation was unavoidable. This shows that even though the law protects consumers, the court will also look at the context and balance the rights of both parties. Let's look at how other countries handle consumers' protection in e-commerce. In the UK, the Consumer Rights Act 2015 protects consumers in online purchase, include digital content. One major issue they address is issue of dark patterns. Dark patterns refer to the design tricks that push consumers to make decisions they don't fully understand. In the case of Office of Fair Trading against Ashburn 2011, the court found that gym contracts were unfair and manipulative. This concept is still not covered under Malaysian law, but our government is still reviewing it and it might include it by mid-2025. And then, in the United States, the Federal Trade Commission (FTC) plays a key role. It protects consumers from deceptive advertising, data privacy violation, and more. For example, in FTC against Amazon 2023, the FTC accused Amazon of unfair monopoly practice. This case shows the importance of having strong agencies like FTC to stand up for consumers. Lastly, in Singapore, the government used the Consumer Protection Fair Trading Act and the Electronic Transaction Act. They also created special bodies like the Small Claims Tribunal and the Consumer Mediation Centre to help the consumers solve problems quickly and easily. This is something Malaysia could also consider adopting. So, by learning from these countries, Malaysia can improve its own system by making clearer laws, forming stronger agency, and offering easier
The
ways.
rapid rise of e-commerce has created a new wave of consumers known as e-consumers. As online shopping becomes more common, it also brings legal and practical challenges, especially in protecting these consumers. In Malaysia, the legal system must constantly evolve to keep pace with changing business models, advances technology, and shifting consumer needs. Effective protection requires strict enforcement, regular updates to the law, and the ability to tackle issues such as data breaches, cross-border scams, and misleading ads. With global e-commerce expected to reach trillions by 2025, adaptive and responsive regulations are more crucial than ever. Malaysia's consumer protection framework for e-commerce is supported by strong interconnected laws. The Consumer Protection Act 1999 was amended to cover online purchases, giving e-consumers the same rights as in-store buyers. This has strengthened trust in online shopping and online e-commerce with traditional retail practices. The Electronic Commerce Act 2006 was updated by legislation recognizes electronic messages, contracts, and signatures, ensuring online transactions are legally valid and enforceable. This provides legal clarity and protection in case of disputes. Other than that, the Consumer Protection Electronic Trade Transactions Regulations 2012 also play a key role by requiring online sellers to be transparent, which is sharing business details and acknowledging orders. This boosts consumer confidence and ensures fair treatment when issues arise. Other than that, dispute resolution is made accessible through the Tribunal for Consumer Claims, which allows consumers to settle problems without lengthy or costly court processes. This empowers individuals to address issues like defective goods and misleading ads efficiently. Lastly, the Personal Data Protection Act 2010 safeguards consumer data. It requires businesses to get consent, protect data, and retain it only when necessary, reducing the risk of data misuse. Altogether, these laws help make online shopping safer and more trustworthy. With strong consumer protection laws, several challenges still hinder effective e-commerce protection in Malaysia. Cross-border transactions are particularly difficult to regulate as foreign sellers may not follow Malaysian laws, making it hard for local authorities to investigate complaints or take enforcement actions. This limits the ability for consumers to seek justice when problems involve overseas businesses. Other than that, Malaysia's legal framework also struggles to keep up with rapid technological and commercial changes. Emerging tactics like dark patterns that mislead users into unintended purchases, or the rise of influencer marketing and algorithm-driven ads are not fully addressed by the current laws. These gaps leave consumers exposed to manipulation and unfair treatment online. Moreover, data privacy remains a concern. While the PDPA 2010 sets out important protections, it lacks clear requirements for timely reporting of data breaches. Consumers may remain unaware their data has been compromised, increasing the risk of identity theft. Broad consent terms also mean many users don't fully understand how their data is used, making them hesitant to shop online. Public awareness is also another issue. Many Malaysians are unaware of their consumer rights or how to act when problems arise. This lack of knowledge weakens the impact of legal protections. Additionally, enforcement agencies often lack sufficient resources to monitor the fast-growing online market effectively, allowing violations to go unchecked. In order to improve consumer protection in Malaysian e-commerce, the current legal framework needs to be updated to match modern technology and shopping habits. Laws like the Electronic Commerce Act 2006, Consumer Protection Act 1999, and Consumer Protection Regulation 2012 should be reviewed and revised to better address today's online shopping landscape. New regulations should specifically tackle issues such as dark patterns and misleading digital marketing, which are common but currently unregulated. These updates will reduce consumer exploitation and increase trust in e-commerce. Stronger enforcement is also essential. Malaysia should enhance cross-border cooperation with other countries' regulators to better handle foreign sellers. Regulatory agencies need more funding, better investigative tools, and modern surveillance systems to detect fraud, counterfeit goods, and data breaches. Establishing a specialized body to resolve e-commerce disputes such as Singapore's Consumer Mediation Center could help resolve issues quickly and affordably. Other than that, data protection must also be improved. Amendments to the PDPA 2012 should require immediate notifications of data breaches and greater transparency about how personal data is used. This will give consumers more control and confidence in using online platforms. Raising public awareness is just as important. Many Malaysians are unaware of their rights or how to act when problems occur, limiting the effectiveness of consumer laws. Joint campaigns such as the government's Shop Safe initiative with TikTok Shop should educate the public on spotting scams, staying safe, and knowing where to seek help. E-commerce platforms must also clearly communicate their policies and consumers' rights. Finally, the government should introduce fair and balanced regulations that protect consumers without stifling online business growth. With consistent rules for all, companies are more likely to innovate and compete fairly. which making e-commerce safer and more reliable for everyone. In conclusion, e-commerce has changed how business is done in Malaysia, and existing laws like the CPA, ECA, CPR and the PDPA 2010 provide a solid base for consumer protection. These laws help ensure fair treatment for all consumers. However, fast-changing technology brings new challenges like data breaches, fraud and misleading acts, especially in cross-border cases. To address this, Malaysia must update its laws, strengthen enforcement, and learn from global best practices. Strong cooperation between the government, businesses, and consumers is the key to making online shopping safer, more trusted, and better for the economy.